After tomorrow? Very urgent or what? For Friday, move it on Friday. Tomorrow also no difficulty, but if it's not urgent, move it on Friday. Okay. Have you filed or not? Yes, madam. Yes. Okay. On a request made on behalf of the BTC, matters are adjourned by 3 weeks to enable obtaining of instructions. Full stop. List on 3 weeks. Today is 7th. 1, 2, 3. List on 2nd of February. 14 and 16. Second. Yes. 2, 2. Urgent. Why is it urgent? Any moment. Okay then. Tomorrow. Yes. Okay. Motion is 18. Yes. What is it? Yes. Richard, I've taken the consent of the other side. On a request made by Sri J.M. Gogoi, Learned Counsel for the petitioners, matter is adjourned by 3 weeks to enable filing of rejoinder affidavit. Full stop. List on 2, 2. When? Day after tomorrow. Why tomorrow? Urgent? What urgent? What urgency? No, it's not urgent. Day after tomorrow. Move it day after tomorrow. We are granting motion, but doesn't mean that move it in a motion day, Friday. If it's urgent, no problem. Friday. Yes, Friday. You're against recounting. Why? You don't want the truth to come out in recounting. Recounting, ultimately, what will be? The truth will come out. So if a process can be shortened by directing recounting, so we are not going to stay recounting. What prejudice will you suffer if you're won by a margin, whether it's recounting once or twice or 10 times, you'll be the winner. We are not going by the procedure. We will go by the substantial justice. Day after tomorrow. Item 26 for withdrawal. Mr. Barua, you want to withdraw this? 3B Barua, Learned Counsel for the petitioner submits that there is instructions to withdraw this writ petition. Also heard SC Health, Mr. Gogoi. Also heard 3B Gogoi, Learned Standing Counsel, Health Department, who does not object to the same. Writ petition accordingly stands dismissed on withdrawal. B Barua, Item 49 for person meetings. Okay. Heard. You have got the copy of the affidavit? Have you filed it? Okay, let it come on record. We'll have it on immediately after the bifurcation. Okay. Pursuant to the order dated, Sri A.K. Bhuiyan Learned Standing Council, BTC, has submitted that pursuant to the order dated 17/12/2025, the affidavit in opposition has been filed today. Full stop. Para. In view of the above, the requirement of personal appearance is stands dispensed with. Also heard Sri M.A. Sheikh, Learned Counsel for the petitioner, who has acknowledged receipt of a copy of the affidavit in opposition. Para. Let the affidavit in opposition be tagged with the court records and the matter be listed for what? Admission. For admission. This item number what? Admission on we can have it on 22nd. 22nd? Yes. This you are also appearing Sri for PNRD. Sri S. Datta, Learned Standing Council PNRD is present. You can take this back, whoever, we can have our court record. Please give a requisition for taking with the court records. I didn't want. Heard Sri G. Uddin, Learned Counsel for the petitioner. You are A.K. Azad. Where is Mr. Uddin? Okay, you are on record. A.K. Learned Counsel for the petitioner. Full stop. This petition was instituted alleging willful and deliberate disobedience of the order dated 12/11/2025, passed in WPC 4561 of 2025. Para. Sri S. Datta, Learned Standing Council. No, Learned Council. Don't say Standing Council. For the response number 1 has, however, submitted that during the pendency of this petition, the order in question has been complied with. Full stop. The aforesaid submission is not disputed by the Learned Counsel for the petitioner. Para. In view of the above, this court is of the opinion that there is no requirement to proceed further with this contempt petition. Full stop. Para. Accordingly, the same is closed. I didn't do. Mr. Das, what is this? Who is appearing? Here for whom? And Mr. Gogoi? Okay. Denying that connections cannot be given in a forest area. Okay. Okay. Yes. What do you say? Okay. We can do one thing. We'll issue notice and you file your affidavit so that the petitioner would have a chance. So far as the petitioner is concerned, NOC has not been granted because it is in forest area. We'll issue notice, we'll examine. Okay. Can you record your name? Okay. Hard. Forest is not a party. You make forest a party, I think. Heard Sri R.K. Talukdar, Learned Counsel, appearing on instruction of Sri D. Sharma, Learned Counsel for the petitioner. Full stop. Also heard Sri B. Das, Learned Standing Counsel, APDCL, who submits that the area in question falls within the which reserve forest? Hangrabari Reserve Forest. Full stop. Para. Sri D. Gogoi, Learned Standing Counsel Forest, who is also present in the court, has supported the aforesaid stand. Para. It, however, transpires that the that the forest department as well as the district administration represented by the district commissioner have not been made party respondents whose presence would be necessary for a complete adjudication of the matter. Para, the petitioner is accordingly granted time of 2 weeks to file appropriate application for implement of necessary parties. Should we give a date? List along with the IA which may be filed. Hmm. Yes, we'll issue notice at this stage. Oh. 1100, not 1000. Cannot be 11,000. Huh? They make the correction even in the. But you hardly have any right in the alignment. These alignments are done, right of way is done. You can at best get some compensation. You will not have any right. Right is very, very limited. Yes, if you can make out a case of malafide that only to cause harassment, but the best judge is themselves, the owner who would install the electricity lines. You may not have any enforceable right. Okay, we'll issue notice for this. Item number, Hertzfree W. Rahman, learned counsel for the petitioners who are aggrieved by the passing of electricity wires over their homestead land. Footstop. It is submitted that though they have made representations for removal of the line, comma, no steps have been taken. Footstop para. Sri B. Das, learned standing counsel APDCL, has however raised an objection questioning the maintainability by submitting that matters of this nature cannot be the subject matter of challenge as the wires are stringed and installed in accordance with the policy and as per the alignment. Para, be that as it may, let notice be issued, returnable on 6th of February. Chief Secretary, yes, Madam. You does State Council for 1, 2, and 5. And 3, 4, and 6 by BDAS. Extra copies. Why is the Chief Electrical Inspector a party? Why? What role will he have? You make the Chief Electrical a party when there is an electrocution case. He has to make an inquiry. Okay. Please give extra copies. Yes. Contractual bill. Where is the acknowledgement? Admission. Now, where is the completion? Where is the 27? Let us see. Completion as of 2019. Now, why are you so late in coming to the court? No. 7 years is a long time. You cannot. When did you raise it? It will be barred even by Tamsir Ali. Term suddenly says that claim has to be a pending claim within the period of limitation. Madam, you are for whom? What do you say? Notice is to be issued. You are not objecting. Isn't this barred by time? You need to come prepared. Hmm. Hmm. The works were completed in 2019. We are in 2026. And how does he explain this? You have not raised this issue. Okay, notice where issue. Heard your BK Gogoi. Heard Sri BK Gogoi Learned Counsel for the petitioner who has approached this court with a prayer for a direction for release of contractual dues. Full stop. It, however, appears that the work was completed in the year 2019. Full stop. Para, be it as it may. Let notice be issued, returnable on 9th of February 2026. Yes, madam. Madam, what is your name? Or revenue? First revenue. Yes, Satyajit Dutta. Standing counsel revenue for 1 and 3. And madam, your name? You are a standing counsel on behalf of RM Das. Give your name on behalf of RM Das for 2, 6, 7, and 8. District Commissioner SR Burwa, State Council for 4 and 5. Anyone remaining? No. Extra copies. Okay. The aspect of maintainability of the repetition is, however, kept open. Same order in item number 7. Completion 2019. Same order. Okay. Parties are the same. Okay. I did 5. Yes. Where is the completion certificate, madam? Where is the acknowledgement? Hmm? Work completion certificate. The court has to point out page number 20 to you. This is the stage of your preparation. Are you required to assist the court or the court will assist you? You are not even able to point out the page number. We are on the work completion certificate. That is page 20. But that is dated 2012. So what were you doing all this time? That request was forwarded in 19. Will it extend your limitation? Then your case become worse. Your case become worse then. Okay, we'll keep them entertainably. I don't think this can be entertained, but notice we are issuing. Heard 3, 8, your doctor, Dr. A to the learned counsel for the petitioner who has approved this court for a direction for release of contractual dues. It, however, transpires that the work in question was completed in the year 2012. Full stop. It also, the learned counsel has also submitted that though a civil suit was instituted, comma, the same was withdrawn on the basis of certain assurance. Para. Let notice be issued, returnable returnable on 9th of February. PWD, Mr. Gogoi, you'll be all the 1, 2, 3, 4 for B Gogoi, extra copies. The aspect of maintainability is, however, kept open. Item 6. Yes, Mr. Madhur. Yes. You filed an additional affidavit. Okay. Okay, Sri N.H. Borbhuya. You're on NH, you're Anil Askar. NH Borbhuya Learned Counsel has submitted that by inadvertence, a document has been left out while presenting the writ petition. Full stop. He therefore prays for and is granted a week's time to put the document on record by way of an additional affidavit. We put a date, Mr. Borbhuya. When? After the Bihu? Can you file it before 19th? Okay, then we'll have it on 21st. 21, list on 21. Sri As Bodhakur, Learned Counsel is present for the respondent corporation. SR Borua for State Council. Item 8. 8. Mr. Mohan. Non-payment of higher charge. Which period? And where is the acknowledgement? Bail is not an acknowledgement. No, we need until there is a completion certificate and an acknowledgement, we cannot entertain a writ petition. No, you file additional affidavit. Heard. Sri L. Mohan, Learned Counsel for the petitioner, who has approved this court for a direction for release of contractual bills. Full stop. It, however, transpires that there is no document from which any acknowledgement of the liability is there. Para. Sri Mohan, the Learned Counsel, accordingly prays for and is granted a week's time to file additional affidavit along with relevant documents. Para. When can you file, Mr. Mohan? We'll have, can you file by 19th? Then we'll have it on 21st. List on 21st, along with the additional affidavit that may be filed in the meantime. Yes, Mr. Goswami, which matter? 9. Who is for 9? Ijjas. Where is Ijjas? Rishikesh Das. We'll have it tomorrow then, or day after tomorrow. None appears for the petitioner on call, whereas you're for whom? Forest Department. PHE, whereas Sri R.R. Gogoi, Learned Standing Counsel PHE is present. Para, in the interest of justice, matter is adjourned to be listed on Friday. Please give the date. 10. Mr. Borbhuya. Two 2006. Oh, this we are not entertaining. 2006, you cannot come in a writ court in 2026. After 20 years. Little amount or big amount is not the question. Sorry. Heard 3 M. No, we are not entertaining. We are not entertaining a writ petition of 2006 in the year 2026. Let us see where page 30. Payments. Where is the acknowledgement? There is no acknowledgement. It is only a statement of payments made. No. Cannot. Bill will not help you. Heard Sri M.H. Borbhia, learned counsel for the petitioner. Also heard Sri B. Gogoi, learned standing counsel PWD. Full stop. The petition has been filed for a direction for release of contractual amount, contractual dues of rupees 3,02,162. Full stop. It, however, transpires that the bill pertains to two works which were executed in the year 2006. Full stop. Para. The learned counsel has submitted that very recently, via a communication dated 10/9/2025, the liability has been acknowledged. Full stop. Para. Sri Gogoi, the learned standing counsel, has, however, submitted that the communication dated 10/9/2025 is not an acknowledgement of, cannot be deemed to be an acknowledgement, and it was only a statement of the payments made. Puts the para. This court, in exercise of its powers under 226 of the Constitution of India, is a court of equity, wherein the conduct of the petitioner is of paramount importance. Full stop. Approaching this court after a gap of almost 2 decades itself would show that the petitioner is not entitled to any equitable relief. Full stop. In any case, the matter involves questions of fact which cannot be gone into by a writ court. Para. In view of the above, the petition is dismissed. Do not sit. Next. Day after tomorrow. 11. Mr. Forecaster? Wishing what? Happy? Today is what? 6th. You are very late. Barred by time. You have to file a section 5. We may consider. Three orders in one writ petition. What are the orders? You were allotted a work. What kind of work? School uniform. Mr. Gogoi, you are for whom? Sarva Shiksha. No, it's already been cancelled. We'll examine. We'll examine. We'll examine that contention. Heard Sri A.K. Purkayastha, learned counsel for the petitioner, who is aggrieved by orders of cancellation of work which was allotted to it. Full stop. The work pertains to supply of school uniforms to the Sarva Shikha Abhijan. Mission or what? Missions. Samagra Shiksha Abhijan. Full stop. Let notice be, is there any arbitration clause? Where is the agreement, Mr. Purkayastha? There has to be an agreement. Let notice be issued. How are you doing the work now? কি করো? क्या बोला आपने? Let notice be issued, returnable on 6th of February 2026. You will accept for all. Madam, you're for one. 1 and 3. What is your name? B. Deka, you're standing counsel. Standing counsel, B. Deka, Miss B. Deka Limited is standing counsel for 1 and 3. Where is B. Gogoi? Then is standing counsel for 2, 4, 5, and 6. Let extra copies be served upon the learned counsel for the respondents by tomorrow. Sri Purkayastha, learned counsel for the petitioner, prays for an interim order. Full stop. However, considering the nature of the work, while this court is not inclined to pass any blanket interim order, it is provided that any fresh NIT issued will be subject to further orders that may be passed in this case. If any fresh tender process is initiated, the same will be subject to. Change if any action is taken towards the execution of the work by fresh tender process, that would be subject to the outcome. Yes, Dr. Todi, item number 12. None. I think similar matter we have issued notice. Heard Dr. A. Todi, learned counsel for the petitioner. Yesterday we Santinath. Yes. This is for a different period. Who is aggrieved by non-disbursal of the freight subsidy to the petitioner, which the petitioner claims to be entitled under the Freight Subsidy Scheme 2013. But your period is 2018. Why are you late? When is it? When is the rejection? Page, rejection, date of rejection. Oh, it is submitted that the claim has been returned in February 2025, 24 on the ground of non-submission of relevant documents. Full stop. It is the case of the petitioner that all relevant documents were duly submitted. Para. Let notice be issued, returnable on 6th of February 2026. Yes, who is appearing? Union of India, Ms. B. Sharma, Standing Counsel, Union of India. Standing Counsel, Standing Counsel, CGC for 1. Then, what is the Secretary Department of Industries you will be taking? SR Barua, State Council for 2, 3, and 4 extra copies. List along with, you have some other matter. Can you give the number? Okay. Now, if you know given a returnable date on 6th, we could have given along with. Okay. Yes, next. Yes, Mr. Sharma. APDCL is before this court against the ombudsman's order. We'll have to issue notice at this stage. Heard Sri SP Sharma, learned counsel, learned standing counsel, APDCL, who by means of this writ petition has put to challenge an order dated 7/6. Why are you late in coming to the court? What is this 2/5/2025? What is 7/6/24 then? And 5/5? Okay, orders dated 7/6/2024 and 5/5/2025 passed by the Learned Electricity Ombudsman, Assam. Full stop. It is submitted that the order is unsustainable in law and the relevant factors have not been taken into consideration. Para, let notice be issued. Returnable on 9th of February 2026. I think both the notices, let's have steps taken by Speed Pursuit AD, steps into working this. 37. Yes, Mr. Goswami, S.K. Goswami, he was there. S.K. Goswami. Forest, what is this? Where is Forest, Mr. Google? Item 37. None appears for the petitioner on call, whereas Sri K. Gogoi, learned CGC, as well as Sri R.R. Gogoi, learned standing counsel Forest, are present. Para, in the interest of justice, matter is adjourned to be listed on Friday. We'll try on Friday. Please inform Mr. Goswami. Maybe he missed out the item. Mr. Bora? Have you got the instructions? No. He was. No, these aspects have been taken into consideration by this court when he had moved this petition. And thereafter, you were directed to obtain certain instructions. Have you got the instructions? Hmm. Yes. Hmm. Why don't you challenge the order then? If the order is with you now, you make a consolidated challenge. At the time of presenting this petition, the order was not with you. Now you have the order. You can make a consolidated challenge, take instructions from your client. We grant some time to you. Heard Sri B.P. Bora, learned counsel for the petitioner, as well as what is your name? M.M. Jaman, A.M. Sharma, A.N. Sharma for Seeds Corporation, for the Assam Seeds Corporation. Your standing counsel. Okay, on behalf of Sri S. Chamaria. What's the para? Considering the order passed on 19/12/2025 and also the further development, Sri Bora, the learned counsel, prays for some more time to obtain instructions. List on Friday or Friday is okay? You're for Agriculture Department. Sri B. Chaudhary, standing counsel Agriculture Board, present. Item 39. 39. Mr. Gupta? Tender with regard to what? ONGC. Oh, you are on caveat, you said. Okay, yes. First, we recharge the caveat. There is no caveat. Did you actually file a caveat? Okay, then doesn't matter. We are hearing you, no problem. But you have to file your power. Okay. Yes, what is it? Tender for? Now, what is the stage? Blacklisting, okay. So if your rejection goes, then the initiation of the process would also go. So your main grievance would be towards blacklisting you, the process which has been undertaken. So what kind of orders are you expecting today? No, here the challenge is with regard to the termination. We'll have to examine. We'll examine. See, this is something which you have done out of abundant caution. Because if you are successful in this endeavor, then the other petition you need not even press, because the very aspect of proceeding against you for blacklisting is the rejection. So I will examine. Okay. But what is your challenge here? Your challenge is not the blacklisting. Your challenge is how can it be? Mr. Gupta, these are separate causes of action. One, rejection of a contract is a separate cause of action, and the proceeding and the move to proceed against you to blacklist is a separate proceeding. You have to have two petitions. You cannot amalgamate. No, you see your first prayer is for decision to reject your bid. That is the first challenge. You cannot amalgamate. It is connected, but these are all separate causes of action. Will be in difficulty tomorrow. I heard Sri A.K. Gupta, learned counsel for the petitioner, who is aggrieved by rejection of the bid pursuant pursuant to a tender notice dated 25 and the subsequent action to proceed against the petitioner towards its blacklisting. Para. In the opinion of this court, both the causes of actions are distinct, and whether a consolidated writ petition can be filed would itself be an issue. Para, be that as it may, let notice be issued, returnable on 9th of February, 9 February 2026. Sri P. Barua, learned counsel, has entered appearance on behalf of the respondents and undertakes to file wakalatnama. Wakalatnama, full stop. Let extra copies be served upon him by tomorrow. Full stop. It is provided that any action taken in the proceeding initiated by the show cause notice dated 8/12/2025 shall be subject to further orders that may be passed. Okay, it is provided that while where there will be no restraint to proceed with the show cause notice dated 18/12/2025, no final orders be passed without taking leave of this court. Okay, okay, we can use the same order. How does it make a difference? Not implementing, not passing, doesn't matter. 44. Similar means? Okay. Okay. What is your name, madam? B. Sharma. Item 44. And this was what item number, Mr. Gupta? Okay. Okay, same order will pass. You are not there day after tomorrow. Unless you say that it's very urgent. Is it very urgent? Then day after tomorrow. Mr. Chaudhary, water resource. We have not understood your grievance properly, Mr. Chaudhary. What is your grievance? There was a contract, NIT. You were interested. Then you had. Yes. Yes. Mhm. Yes. Rejected. Yes, Mr. Das. What happened in the earlier case? No, what orders have been passed? Okay. Then we'll close this. Heard 3, item number 43, AHMR Chaudhary, Learned Counsel for the petitioner. Also heard 3, RM Das, Learned Standing Counsel, Water Resource Department. Para? Considering the subject matter involved and as agreed to by the Learned Counsel for the parties, comma, the instant petition is taken up for disposal at the motion stage. Para? As per the facts projected, the petitioner is a class 1 within bracket A capital contractor and pursuant to an IFB for the work, namely NT erosion so and so. The petitioner was interested to submit the bid. However, there was a requirement to accompany the bid along with a certificate to be issued by the executive engineer. Full stop. It is the case of the petitioner that though such certificate was applied for, comma, the same was not made available till the last moment, for which the bid had to be submitted without such certificate. Full stop. Para, Sri Chaudhary, the Learned Counsel for the petitioner, has submitted that the petitioner cannot be made to suffer prejudice because of inaction of the officer of the respondent department. Para, Sri RM Das, Learned Standing Counsel, has, however, submitted that the projection made may not be entirely correct on facts. Full stop. He has submitted that a certificate was indeed issued by the concerned executive engineer on 23/12/2025, and in fact, he has presented before this court a copy of the said certificate. Para? That being the position, this court is of the considered view that the interest of justice will be served if a direction is given for consideration of the bid of the petitioner along with the certificate which appears to be on record. Full stop. It is accordingly directed that the bid of the petitioner be considered in accordance with law along with the certificate dated 23/12/2025. Full stop. The direction is, however, only for a fair consideration along with other bidders, and the work is to be allotted strictly in accordance with law. Copy of the certificate dated 23/12/2025 is made part of the records. No, other considerations are there. Other considerations. We have already said the consideration of the bid has to be done strictly in accordance with law. We have said that. 41. 41. Yes. ONGC. They are not on caveat or what? Mr. P. Barua was appearing. Will Mr. Barua appear? Where is Mr. P. Barua? What is it? No, what is it? Yes. Mr. Chaudhary, please take your seat. 30. Yes. Hmm. Bank account, GST number, it was initially attached to my lender book, has now been changed. So I basically go the court, I get this clearly, and the work shall not be issued to direct. Mr. Barua. P. Barua. Against the ONGC. If you can appear tomorrow, we can have. Tomorrow? You are there tomorrow? Or if you can try at 2 o'clock, we don't mind taking up at 2 o'clock. 2 o'clock, can you take instructions? You try to take instructions, if possible, 2 o'clock, otherwise tomorrow. Okay. Please give a copy to Mr. Barua. Mr. Chaudhary, give a copy to him. $42. $42. Yes, yes. Allotment of toilet block. Okay. You had participated in the tender process. Then what happened? Hmm. Hmm. Okay, what had happened? Hmm. Hmm. Okay. Challenge was in this court. Okay, what had happened? 6901. No, no, 6901 is this WPC. What happened there? Five 12, the petition was closed. Okay. To cancel the tender. Okay, 1511 tender cancelled. Yes. No, 1511. Yeah. Yes. Hmm. Yes. Yes. Now, what is your grievance? Tell us the grievance, Mr. Moshe. Hmm. 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 No, no, the third tender process, tender notice is 2912. So what prejudice are you suffering in so far as participating is concerned? No, those are gone. Now in 2912, why can't you participate? That was the auction period. We have understood that. Now you say that that period, that tender has been cancelled, and again, fresh notice of 2912 has been given. So 2912, what is your prejudice in participating in 2912? That has not given you any right. You have to have an enforceable right to come to the writ court. It is not the process has culminated, you have been adjudged as L1, in spite of that, there's a cancellation. Then we probably would have examined. There may be some genuine reasons, relevant reasons. But here, where is your right? Hmm. Hmm. No, those are not relevant, Mr. Sharma. Are not required. We are dismissing this. You don't come to the red court. There has to be some right which vests upon you to enforce it. No right have that. You're only a prospective bidder. It has been cancelled. No, no, no. I'm sorry. Sorry. Heard Sri P.R. Sharma, learned counsel for the petitioner. Also heard Miss M.D. Bora, learned standing counsel, Transport Department, and Miss K. Borpuja on behalf of A. Chamwala, the Standing Council for ASTC. For response number 2, para. Considering the subject matter involved, comma, the writ petition is taken up for disposal at the admission stage, at the motion stage itself, full stop. As per the facts, please have your seat. As per the facts projected, the petitioner had participated in an auction process initiated by the ASTC dated 14/11/2025 for allotment of a toilet block for running business at the western side of the ISBT Betkuchi on license basis, full stop. The said tender process was, however, the subject matter of challenge in WPC 6901 of 2025, full stop. The in the said writ petition, comma, submission was made on behalf of the ASTC that the tender process was cancelled, and accordingly the writ petition was closed on 5/12/2025, full stop. Thereafter, a second tender notice was issued, pursuant to which the petitioner had again participated, and it was stipulated that the auction period would be from 29/12/2025 to 30/12/2025, full stop. However, it is the case of the petitioner that even the second tender process was cancelled and another tender has been floated on 29/12/2025, full stop. Sri Sharma, the learned counsel for the petitioner, has submitted that the impugned action has been taken only to suit some favored person and to minimize the competition, full stop. Para. This court is, however, of the opinion that no enforceable right has accrued upon the petitioner only on the strength of being a prospective bidder, full stop. Unless any enforceable rights is vested on a party approaching this court, comma, this court being a court of equity shall not entertain, shall not exercise its jurisdiction, full stop. Para. The petition is accordingly dismissed. Yes, next. Yes, Mr. Chaudhary.
And initially we not went to the horizontal system. The land was agricultural land and there was an NOC issued by the losses dated phase 21. That were really substantial compliance of the requirement of the emphasis by the Act. NOC whereby issued with paper of individual population for setting up local vehicle outlet and the cosmetic effects. So that way will not NOC is there. So it was not an agricultural. Now what has happened, Lord? Now because an act taken on this law of 2050, according to this description in this act.
No, we know about this act, yes.
Now section 8 and 9 is important.
Yes.
Yeah.
Assembly and regulator, yes.
Page number 1-3.
Which book are you having, Mr. Chaudhary? No, we have it. Please give the name of the act.
Regulation of declassification and transfer.
2015 Act. 2015 Act. Just a minute, please. पैसे में कितना? नहीं तो नहीं. क्यों बस? Yes. Since when are you running the petrol pump? You're running it? Yes, Mr. Barua?
So now the communication has been issued to the oil company that the.
No, even otherwise, if it's an existing concern, would be applicable retrospectively. That would be the question we have to answer. Mr. Barua? No, the aspect of agricultural land came after an act of 2015, which is after the commissioning of the petrol pump, the business. Now, if by a subsequent act, you make something which is not legal, will the previous act can also be will it have effect on the previous act also? Something which has already been done. Oh, okay, heard. Sri K. N. Chaudhary, London Senior Counsel, assisted by Sri J. Islam for the petitioner. Full stop. The petitioner is aggrieved by a letter dated 17/12/2025 issued by the District Commissioner, Kamrup, to the HPCL, HPCL, HPCL for what? For not to release petroleum POL, full stop, POL products, full stop. Okay. It is the case of the petitioner that though the reason has been cited that the land in question is an agricultural land in terms of the so-and-so Act of 2015, the business was commissioned prior to the enactment, and in any case, there is a provision for regularizing such business by payment of penalty. First, in this connection, the London Senior Council has placed before this court the provisions of section 8 and 9 of the said act. Let notice be issued, returnable on 6th of February 2026. Sri Revenue Department Satyajit Dutta, Standing Council 1, Revenue, District Commissioner and Food 2 and 3, SR and Borua, State Council 4, anyone HPCL. HPCL will take steps, Mr. By registered post release. Sri Chaudhary, the London Senior Counsel, prays for an interim order. Taking into consideration the facts and circumstances and also the deeming provision in the Act of 2025, it is provided that till the returnable date, the impugned direction dated so and so shall remain suspended. This is your book, perhaps, Mr. Chaudhary. Please collect it from our court master. Extra copies, Mr. Islam. Extra copies. Oh, extra copies, extra copies. 45, Mr. Kaur.
I purchased stocks around 5 lakhs. Then on the September 15th, incident happened. It just been, I decided to open my shop. Then there were some nearby shops also there. And their relations and then they get an interest into our shop. And they are politically neutral. So they are subsequently accused the municipal group and not my people. And they got their my NOC which was issued earlier prior to getting the information.
It has been cancelled.
Yes. But Inspector said,
Hmm.
Inspector has said that I have Confirming all the excise acted rule. Now, there is no consequential order, just for the, not granting.
Mr. Gogoi,
The clean order is that you must see. Although they have not asked me to stop, but it's sort of the situation has been changed. I thought that I will go legally.
we will issue notice to you to sort out the issue. If in the initiation of grant of license, you have taken care of everything, now you have to take care of the law and order also. Is there any violation? Hmm. Hmm. But those were factors which you have taken into consideration prior to grant of the license as well as approval of the site. Now okay, we issue notice at this stage. See, we cannot direct you to sell. No, see. But see, we don't have too much of an idea, but does it get expired? Or will it, value will be even get higher? You say the older the wine, the better, the quality gets better. Very worried, you can sell it at a premium price later. There are other process of completing the stock. Some of you are very happy. Some of your friends are very happy. Mr. Kaur, it will be difficult for us to give a positive direction because unless there is an order restraining, we can stay that. Why don't you submit an application, representation to the district commissioner? We'll ask to consider that. Okay, that I think, is it on record? Which pair? Heard Sri BD coordinated Senior Council assisted by Sri J Singh for the petitioners. Full stop. It is the case of the petitioners that an IMFL off retail outlet was duly allotted to the petitioners in the approved site. Full stop. However, the business could not be run due to certain objections by the public of the locality. Full stop. The petitioners also claim to have lodged an FIR, in spite of which no steps have been taken. Full stop. NOC has been cancelled in the meantime. So it further transpires that the NOC has been cancelled in the meantime. Full stop. Para. The Learned Senior Council submits that all the relevant aspects were taken into consideration before the license was granted and the site was approved, and therefore it was the duty on the part of the respondent authorities to make a conducive atmosphere for running the business. Para. Let notice be issued, returnable on 9th of February 2026. Yeah, for all, Mr. R.R. Gogoi. Sri R.R. Gogoi Standing Council exercise for 1, 2, and 3 extra copies. 4 extra copies. You does 4, huh? Para. Three. For the Learned Senior Council prays for an interim order. Para. Considering the facts and circumstances, while this court is of the opinion that no positive interim order can be passed at this stage, it is directed that if the petitioner approaches the concerned district commissioner. Concerned district commissioner and superintendent of police with representation, the same are directed to be considered and disposed of by a speaking order. Okay, 12th returnable. Not 12th, 13th. 13th, Friday. Speaking order, কি কল লাষ্টত খিনি? No, তাৰ আগৰ খিনি কেতিয়া দিব representation? Which may be submitted within a week from today. Huh? The speaking orders may be passed preferably before the returnable date.
Item 15.
Yes, Mr. Mr. Mahanta will be arguing. But when do we have then? Tomorrow, day after tomorrow, when? Mr. Mahanta? Order dated 35. Affidavit filed, Mr. Gogol? You have got the instructions, Mr. Gogol?
And by reading that one, there were times my cheek more than even 10 miles. Therefore, they are not about that matter. They are not about that matter. The lordship is that shows the reverse.
You have filed the affidavit.
Yes, yes, I have to take what I amount that what I think. So, if you were, only for 28,000, 32 lakhs over. It might have, they said that you get 50 plus, then only here I think. But here, my amount, that's the calculation for wrong man. But my money, but 3.24 line there, my lord. 3.86, my lord.
Yes, Mr. Gogol, you
That's why.
give us a solution. What kind of orders would serve the interest of justice? But what about the amount which is lying with you? We have submitted that the rules are there, but can something via media be done? Because a considerable amount is also lying with the department. We want a completion of the matter, because to consider the appeal, there is a requirement under the rule to pay an amount, and that amount appears to be a substantial amount. When a huge amount is lying with you, whether without insisting on the payment.
What are the departments to get money?
Just a minute, just. How much money is lying due to you, Mr. Mahanta? Have you quantified? Where have you? No. Where have you quantified? Where? Which paragraph? What is your response, Mr. Gogoi? How have you responded to this? No, regarding that certain dues are lying with you towards payment of KISS money. And he has made a specific statement in paragraph 29. How have you responded? 38.
But now they are claiming I have to pay 52 lakh, then they will have that.
How this 5119 has come? 25% of what? Okay, but Mr. Gogoi will have this tomorrow for disposal. Tomorrow? Today there are some matters, motion tomorrow, we have time, hearing day. There's no point adjourning matters of this nature. Vacation means what? Okay, okay, we can have it on a day, on 28th, Bistari. 20, that's a Tuesday. We'll dedicate some time to this. And you talk to your officers, try to come up with a via media. See, the appeal, we want the appeal to be considered on merits. These are all technicalities of deposit. Now, deposit is to ensure that they cannot just, whatever the due is upon them, some security is given to you. But considering the entire facts and circumstances, if you can find out some via media, it may not be in the form for written instructions. We can incorporate it and give a direction for consideration of the appeal on merits. Okay. Heard Street TJ Mamta Leonard Senior Counsel assisted by Sri Ann Alam for the petitioner. Para. Sri R.R. Gogoi Leonard Standing Counsel Forest is present, who has submitted that certain instructions have been received. Para. List for admission hearing on 20 this tarikh. No, not important.
Seventeen.
17, Mr. Yes, please. By whom? PWD. Yes, Mr. Bhuyan? In that case, you have to put your challenge in the civil court. If they are assigning reasons that your performance was not satisfactory, their reasons may not be correct. But now once the reasons have been assigned, the correctness of those reasons will be difficult for us to determine. Each page. $36. Yes. Yes. Yes, Mr. Bhuyan, how do you justify this? Once you have given a routine maintenance completion certificate on 24/4/2025, can you withhold or hold back the security deposit? Where is your affidavit, Mr. Bhuya? What have you stated, paragraph? Forty? It is at 49. But how do you justify this certificate? Which paragraph, madam, you have stated about annexure H? Paragraph 9. How is paragraph 9 answered? Then 8 and 9. And according to one draft, problems from the same during the routine maintenance period. The period has received period two. There is a necessary for generation of a DLP completion certificate by the EMARG. Has it been done or not? You get specific instructions on this aspect of a system generated DLP certificate. You may have a good reason that at the time of execution it got delayed, but there is also equipped with a certificate. And you said that within the extended period, you should have completed the work satisfactorily. And that needs to be supported by e-generated DLP certificate. How much is the SD amount, madam? What was the work involved? Where? Gwalpara. Mr. Bhuya, you are appearing for the PWD. Can you have Mr. Gogoi? Okay. I will try to dispose of this. Okay. Kindly show us that part where the SOP has come after the completion of the work. Okay. For some time being, or let him come, then we'll try to take a call on this.
Item 19. There is a file composition. Specifically mentioned, what is the amount we use for us.
Have you admitted? Then we can dispose of by following Tamsir Ali. What else can we do? It's a full bench. Tamsir Ali has said as per the age of the bill, chronological order. Yes. We cannot say anything above Tamsir Ali. Okay. I heard Sri T.K. Mishra, Learned Counsel for the petitioner. Para. Sri S.R. Badua, Learned State Council, has submitted that though affidavit in opposition has been filed on 25/11/2025, he would like to obtain further instructions for which he prays for some time. Tara? When? Tell us. On request list on. No, we'll leave it on 28 তারিখ first week of February. Okay, on 2nd of February. 2/2. Affidavit filed. It's a new matter. What is the matter? Okay. I heard 3A Decca Learned Counsel for the petitioner. Full stop. Notice was issued on 24/9/2025. Para. Miss Udas, Learned State Council prays for and is granted 4 weeks time to enable her to obtain instructions. Full stop. List on 11th of February. 22. You are the council? Okay. And 21 same hobo. 22 koba. Heard 3A Harry Decker, Learned Counsel for the petitioner, where notice was issued on 24/9/2025. Para. Miss Udas. Okay. Learned State Council has submitted that instructions have been received and the affidavit in opposition has been prepared, which should be filed shortly. Filed shortly. List on 11 question, I got to 11/2/2026 along with WPC Kumbata Digib. Yes, Mr. Chaudhary. Is it? Mr. Podar for whom? What is the matter, Mr. Chaudhary? Then let Mr. Mahanta come. Mahanta for a private respondent and Agriculture Department. Public Works Department. Okay. And you are also a private respondent. You have filed the affidavit. Okay. Let Mr. Mahanto come. We'll try to do this matter. Mr. Gogoi, some matter of yours? Yes. See, we have seen your affidavit. You have said that it has to be an e-generated completion certificate. But Madam is trying to show that this requirement of the SOP through the SOP has come after the work. And you have also, she is also banking upon a certificate that the maintenance work was also done in time. And that is okay, but you have not disputed the certificate. You have only said that we want a e-generated certificate because the completion of the work was done within the extended period of time, not during that time. There was a delay in completion. See, delay is one factor and maintenance is another factor. Now, you are trying to bank upon a certificate which is e-generated, certifying that the maintenance work was also done. See, for these technical aspects, should the petitioner suffer? The matter would have been different if you have disputed the certificate. The certificate is not disputed. That is it. Now, why you want time for what purpose? Give a date. Give a date then. When? Okay. Well, heard Ms. D. Musari, Learned Counsel for the petitioner. Also heard Sri B. Gogoi, Learned Standing Counsel, PWD, to praise for some more time to obtain necessary instructions. Para, on request, list on 28. What is that? 28. 28-1. We'll try to dispose this off.
24.
Mr. AG, you are here. Some big matter or what? Notice was issued. Have you filed your affidavit? Affidavit filed? Okay. You filed your affidavit? Okay. What is your name? Heard Sri S.A. Hussain, Learned Counsel for the petitioner. Para. Sri D. Sekia, Learned Advocate General, Assam, assisted by Sri D. Dekar, has appeared for the AIDC, and has submitted that the response to the writ petition would be filed, for which he prays for some time. Para. How soon can you file? Okay. Do we fix a date then? List on 4th of February. By which time the affidavit in opposition is required to be filed. Anything? 6th. 6th, okay. 6th. 6th. Ah.
25.
Electrocution case. Now, have you got a copy of the report? The report says affirmative. So there is no requirement to file affidavit. Okay, you give copies to them. See, if you have disputed the allegation, then we would have insisted on an affidavit. If you are admitting, then based on the report, we'll make it a part of the writ petition. See, these matters of compensation and all, if it's a genuine case, we should not delay it. You give copies to the other side and we'll have it. When? Okay. Well, if you file it today, it's okay, but you should not pray for time. Okay. Heard Sri M. Hussain, Learned Counsel for the petitioner. Para. Ms. Yudas, Learned State Counsel, has submitted that the report of the senior electrical inspector, chief electrical inspector has been obtained, and in this regard, an affidavit is also prepared, which would be filed shortly. Full stop. Para. List on when? 28. 28. 28. 28-1. 28-1.
46 to 48.
Without issuing. Affidavit is filed. 22-1 is of 25. 2960, yes. These are 22 matters. We have not filed affidavit. Why, Mr. Das, you are for whom? You have not filed affidavit. We can file it today then, or by tomorrow? Day after tomorrow, Saturday, you cannot file. Or Friday, Friday you file, okay. Okay, then we'll have it immediately on the reopening. Okay. Herds, okay. But how soon can you file the affidavit? How soon can you file the affidavit? Okay, well, okay, we'll grant some time as a last opportunity. Or last opportunity will grant time. 2nd of February. Okay. Hart Street E. Chakraborty Learned Counsel for the petitioners who has submitted that in spite of a lapse of considerable period, no affidavit in opposition has been filed. Full stop. Both Miss U. Das, Learned State Counsel, and Sri D. Das, Learned Counsel for the private respondent in one of the writ petition have prayed for some time to enable filing of affidavit in opposition. Para, considering the facts and circumstances, a last opportunity is granted to the respondents to file such affidavit in opposition. Para, list on 2nd of February. State is a party here. Wherever you file the affidavit, if it's a common affidavit, will otherwise, if there is no affidavit, we cannot help you.
The cause of action is totally different. What's been ordered.
It's up to you on notice. If you choose not to file affidavit, you have to face the peril.
In item number 48, there is an interim order, my lord.
Interim order, if any, stands extended till the next date of listing.
Of the Lordship has fixed it on 2nd of February.
Yes, 2nd February, Monday.
Lordship, can it be on a hearing date, my lord? Then Lordship can.
Let them file the affidavit.
File.
Yes.
This is
26, Mr. S.K. Das. Who is S.K. Das? Santanu Kumar Das.
Passed in this case, Lord.
Huh?
Order has been passed in this case.
Picking order has been passed.
Lord, last order was the final payroll. And the remaining amount of 30,000, we have to process the amount. Lordship. Perhaps
I think it's been disposed of almost.
not almost disposed of.
None appears for the petitioner on call. Whereas Sri N. Upadhyay, Learned Counsel, has appeared for the
That's for
respondents. Full stop. Sri Upadhyay has referred to the order dated 18/12/2025, passed in the present proceedings, in which this court has taken into consideration the speaking order dated 13/6/2025, passed by the authorities in this regard. Full stop. This court has also noted the further observations made by this court in the aforesaid order dated 18/12/2025. Para, in view of the aforesaid facts and circumstances, comma, this court is of the view that there is no requirement of any further adjudication of this, further continuation of this matter, and the same is accordingly, and the same accordingly stands closed. Any parcels? Yes, sir. Not any particular order this. 27, yes.
Lord, a portion of the amount has been paid on 7th of January. Some balance amount remains. Perhaps they'll have to make some arrangement.
But interest rate. 1.20 has been paid. And therefore rest of the amount, there is no budgetary provision yet in this budget. Second para can you see the budget.
Okay.
Under the.
Heard Sri KP Pathak, learned counsel for the petitioner, as well as Sri D Nath, learned counsel appearing for the respondents. Para? Both the learned counsel have jointly submitted that a substantial amount has been paid in the meantime. And Sri Nath prays for some more time to obtain further instructions. Para? In view of the above, matter is adjourned to be listed. When?
They have to take up in the next financial year.
Listed will keep a continuity on 27th of February.
Deeply obliged.
In the contempt petition, my lord, last occasion they were, my lord, taken time. That they have to clarify them, my lord.
Affidavit filed.
The incumbent minor is the principal secretary, he is no longer in the department, he is transferred to some other department. Nonetheless, minor, he can file an affidavit, individual affidavits in all the 4 contempt cases. So 4 affidavits are there. So, minor, the retributions were disposed of the admission by the respondent that the outstanding bill amount towards supplying of gaseous materials, minor.
Supply of?
Supply of gaseous material during flood season. But this was the issue, it was a report. Those requisitions were disposed of, directing the respondents to pay the outstanding amount. Now thereafter, my lord, having disposed of those requisitions, now the authorities have undertaken a verification exercise as a matter of abundant precaution. Now a committee, high-level committee has been formed, my lord, including my lord, the revenue minister and all other my lord, senior officers of the department. And the committee has also my lord, submitted its report. Now the latest instruction which we have received, my lord, today itself.
Where?
No, that I'm not aware about today that probably with him, my lord. But one thing your lordship kindly see, this is the order passed by this honorable court. It was the order after the filing their affidavit, after consideration of the order. Now, my lord, there another committee has to examine the high court order, my lord. Is it, my lord, permissible, my lord? If it is permissible, my lord, then there will be no value of the high court order, my lord. They are the division bench, my lord, in my lord government, and they will decide. Then why do they admit, your lordship kindly see the order, my lord, order passed by this honorable court. Then now let them, why they have not paid my money?
Just inviting a reference to the committee from Mr. Pujari, if you are aggrieved by the order of this court, you
Then
have
they can
remedy.
file appeal.
You have remedy in law. You cannot sit over the, Mr. Mohanty is correct. Where is the question of examining? How do you examine? If you examine, if you find fault with the order, orders may be fallacious. You challenge it in the appropriate stage, appropriate forum. Yes, we will not have this kind of a submission accepted.
For a moment, madam, item number 28.
Was there a direction or not?
So there was a direction.
If
but
there is a direction, you have to comply with the direction. If the direction is not compliable, you have to file an appeal and get it rectified.
Right, that's it. That we will not comply.
No,
I can
order-
see that-
No,
I
no,
can see that-
you cannot say that we will comply with it. You have to. There is the mandate of law. Now, the order is of which date?
For a moment,
Order of which date?
22/5/2024.
Sufficient time is.
So therefore.
We see, Mr. Borpujari, let us be very clear. We are not interested in this kind of a communication. You advise your clients that either you comply or you face the whatever There is hardly any scope for explanation, Mr. Borpujari.
It's so uncertain term whether we have admitted by filing an affidavit in the writ proceedings. No, kindly see the observation, my lord, kindly see, for my satisfaction.
Let us see the order of this court,
Yes.
page.
Page, my lord, that lordship will find page. Well, page 15,
1-5.
1-5.
That is a part of the order.
Oh,
Kindly see the fourth paragraph, my lord.
yes,
Today, my lord, today,
yes.
today, when the matter has been called, similar order has been passed in all the writ petition.
Mm,
An instruction dated 22/5/24 has been placed before this court by so-and-so, Lanas and Legal Revenue Department, issued by the Joint Secretary to the Commissioner of Revenue State Directors, indicating that the bills of the petitioner shall be released within a period of 3 months.
Hmm.
So we will release the bill,
mm.
albeit some verification, albeit some verification.
Where is that?
No, it is not.
Where,
there.
how do you read into those orders?
This is, my lord, that we will.
What is the meaning of albeit some verification? What is the meaning of albeit, Mr. Borpujari? Please, please make us understand what is the meaning of albeit? What is albeit? What is albeit? What is the meaning of albeit? You use this expression very often. Do you know the meaning of albeit? What is albeit? No. You don't know the meaning of albeit. No. You cannot read into. How do you read into orders of this court?
No, my lord, I am not indicating the order.
You cannot come to the operative portion.
Yes.
Mr. Borpujari will not accept your submission at all. In a contempt proceeding, will not accept. Either you comply or you face proceedings.
Cannot comply. The report
No,
says-
more than a year has passed. We are not dependent on a report for compliance. We initiate contempt proceedings.
Why not that the.
We'll initiate contempt proceedings.
My lord,
And we'll have their presence, personal presence.
as for respect, if I may submit, my lord, let the present incumbent be immediate, my lord.
See, we have to have an explanation of that incumbent during the period while he was holding office. If we go technically, we'll also go very technically. This particular gentleman was in office for that period. He needs to explain what action did he take for compliance of the order. Oh, that is not a compliance. We want a compliance.
The government has taken a decision, form a high level committee. my lord,
Right,
to-
that is contempt, that itself is contempt, my lord. Your lordship kindly.
Mr. Borpujari, you have understood. You are not required to be advised on this aspect. See, had it been a writ petition, we are open to your arguments. Whatever is reasonable, we try to decide.
There will be
But,
a court order.
but this is the court of the order of the court. You need to, there is no other alternative. Either you challenge in the higher forum, get it rectified, get it dismissed.
In fact, my lord, one submission I made, the judgment passed by this honorable court.
Heard
Not only,
Sri Tija-
not on
Heard
instruction.
Sri
then
Tija
on
Mahanta.
the affidavit, my lord. They have
Heard
filed an
Sri
affidavit,
Tija Mahanta,
affidavit.
learned senior counsel for the petitioners. Also heard Sri K. Borpujari, learned counsel appearing for the respondents, who has placed before this court a communication dated 7/1/2026 issued by the Joint Secretary to the Government of Assam Revenue Department, full stop. A reading of the said, reading of the contents, TNTS, of the said letter would, however, give an impression that the department is sitting over the orders of the court, which are the subject matter of these contempt proceedings, contempt petitions, full stop, para. At this stage, Sri Borpujari, the learned counsel prays for some time to obtain further instructions towards the steps taken for compliance of the orders in question. Full stop. We'll fix a date. List on. On 11th of February.
My lord, your lordship already too late, my lord, your lordship. These are suffering, and this order was passed on the basis of the affidavit filed by the petitioner, by the respondent, my lord. That is quoted in the judgment, my lord. What they have stated. There is an inquiry done by the vigilance cell of the chief minister.
okay.
That is, my lord. That is also clear.
11th. D-Nat will give, huh? Output purpose and D-Nat for the respondents. Okay. 11 come up with better instructions, okay? Otherwise, we will not have any other option but to initiate contempt proceedings.
Develop.
May I please, Your Honor?
Yes, ma'am.
The last order date 24/11/25, we have issued notice via Speed Post and Justice Service, Your Honor. And in flag A, we have given our affidavit on the same, Your Honor. Contempt proceedings.
Just a minute, please. You have filed affidavit, madam.
Yes, Your Honor.
Annexure A, flag A.
Your Honor. Your Lordship.
Yes, where is Mr. Gogoi? Anyone for Public Works Department? Mr. Barua? This is something serious. A contempt proceeding has been initiated. Notices have been issued by Dusty, affidavit filed. If they are not,
My husband has died, Your Honor, waiting for justice, Your Honor.
it'll be in difficulty.
My hard-earned money has been not released yet. I don't know, 32.
It'll be in difficulty. Unnecessary, we don't want to make an order for personal appearance. No, you are not, you cannot be aware, this is a contempt matter. You cannot appear as a standing counsel, we are just trying to put it to you. Take instructions unofficially and do whatever is required, because the order of this court is for initiation of contempt proceedings. It is not issuance of notice in a contempt case. Because earlier occasion, even after service, none has appeared.
Yes, Lordship.
When can we have? Where is Mr. Gogoi? Can you call Mr. Gogoi? After a while, madam.
Yes.
Update
33. Yes, madam. IA4?
Yeah, they have filed for extension of the time lawsuit provided for filing appeal, statutory appeal.
Okay.
Lordship, on the last date when they submitted the appeal, lordship, the portal is not receiving. I have received some instruction why it was, but some clarification is required. Lordship may take it immediately after being.
No, we can grant some
Lordship-
time. Madam, you are appearing online.
Lordship,
Earlier.
what has happened in this case? Lordship,
No, Mr.
Lordship,
Chaudhary has already explained that there is some issue and he'd like to take instructions, but we can allow your application for extension. You can file it in the extended period.
Lordship, not for extension. Lordship, may kindly see that in this case, the case was dismissed because they had dismissed my appeal because it was filed manually, not electronically. Thereafter,
That we have
Lordship had
understood,
filed.
madam. We are trying to pass an order in your IA, by which you are seeking extension of 30 days to file the statutory appeal electronically.
Yes, Your Lordship. Lordship, may kindly see that the CBIC has in the meantime issued a, Lordship, I may kindly, may be allowed to submit only one paper. The
Yes.
CBIC has now issued that it cannot be filed electronically. The
Yes.
CBIC has issued the circular, Lordship. We had filed a grievance. They have already said that it cannot be filed.
Can you,
Lordship, may kindly see
are you
that
aware of
if-
this, Mr. Chaudhary? Have a look at this. We can allow this in the second half or after some time.
Yes.
Madam, after a while, let Mr.
Yes, Your
Chaudhary go.
Lordship.
Okay, I can refer this. I can be disposed of today. Mr. Gogoi, where is the other council? Your Contempt proceedings has been initiated and notices were issued by Dusty also. And none of them have appeared or are Public Works Department officers. You take instructions because we don't want unnecessary harassment. You just have a look. But it's- anyway, if
But when my lord, it was not released, so that notice was issued. I will.
nonetheless, but today now none is appearing, no names are shown. When can we have?
My lord, let it be after the.
Madam, we'll have a date, fix a date immediately after.
Definitely, Your Honor.
What is your name, madam?
Chandana Sharma.
Heard Ms. C. Sharma, learned counsel for the petitioner, who has drawn the attention of this court to the affidavit filed in terms of the order whereby Dusty service was permitted. She has also submitted that in spite of such service of notice, none of the respondents have entered appearance. Well, Sri V. Gogoi, learned counsel, has however appeared and submitted that he would be appearing for the respondents, for which he prays for some time to file the formal wakalatnama. List on, we give a date, 30.
Lordship, my husband died waiting for the money.
And
Order
I-
was of 8 for 2024, Your Honor. If the date is earlier, it will be highly obliged.
See, next week is a holiday. We can have it on 28th, not before 28th or 27th.
Deeply obliged.
26th is a holiday. 28 doesn't matter. 28 to 8.
Deeply obliged.
And you instruct your clients to comply with the order. You come up with instructions. What steps have you taken for compliance of the order in question? Okay, next.
Item 24.
Mr. Gupta,
My lord, the steps has been taken, my lord, the office note reflection on the service. You have to-
petition is for what?
My lord, we're praying for setting aside the order passed by the.
You are appearing for the respondent.
Only,
Which respondent?
Sole respondent.
only one.
Mr. Gupta, writ proceeding, you have not made the tribunal a party. Why? We are not exercising appellate powers or revisional powers.
My lord.
You have to make the adjudicating authority a party, whether it comes to defend this case or not, that's a different matter. You make it a party. It'll be a defective petition. The fight is between you two, we'll adjudicate,
No.
but the tribunal has to be a party in a writ proceeding. Okay. Will you like to file affidavit?
Yes.
But it is based on, you're challenging an award.
Yes, my lord.
What, a reinstatement has been directed or what?
My lord, the ASI, the Archaeological Survey of India, my lord, it's not an industry.
No,
There
what
are-
what is the direction?
My lord, direction is to pay the certain area, my lord, to the petitioners, my lord.
It arose out of a reference or a section 2A application?
Not reference, my lord, section 2A application, my lord.
2A, he has
Yes.
approached the tribunal directly,
My lord, my lord.
the workman.
Yes,
He was dismissed from service.
yes, my lord.
Okay, you file your affidavit in the meantime, and if you want, but otherwise, your affidavit, unless there are new facts, did you contest the proceeding?
Yes, my lord. we have
Contested?
Contested.
You had taken up the plea that you are not an
Yes.
industry.
Yes, yes.
What was the answer?
No, it was answered in negative, my lord.
No, that we, of course, you know,
My lord.
that is the subject matter of challenge. What are the reasons assigned for holding you to be an industry?
No, no reason, specific reasons were given.
Okay. Heard Sri H. Gupta, learned CGC for the petitioner. Also heard Sri
Yes, my lord.
S. Raman, learned counsel, appearing for the sole respondent, who prays for and is granted 4 weeks' time to file the affidavit in opposition. The records of the learned tribunal have,
My lord, next item is also out.
okay, same. Okay, do it.
ASM.
The records of the learned tribunal have been received. Para? Sri Gupta, the learned CGC, may also file appropriate IA for implement of necessary parties in the meantime. We give a date, Mr. Yes, when? 4 weeks, can you file the affidavit by 4 weeks? Okay, list, give a date after 4 weeks. We'll have it on 9th of February. Is it okay? 9th February. Both. The workman is the same, is different.
Workman is different.
Records beleg negligent. আহিছে বেলেগ কে আহিছে? Well, separate orders, Maridip, huh? You have not filed your former Lokatnama. You have filed already. The name of Sri Rahman be reflected in the court list. Okay.
50.
Mr. Sheikh,
Hello.
IA4?
I have for some arithmetical correction, my lord.
Arithmetical.
Yes, my lord. Some typographical mistake.
Why arithmetic had come in?
My lord, in type, my lord, some mistakes were there. Two places, my lord. I am referring to para 12, my lord. Date may be corrected as 38/2020 instead of 24/7/25. And in the prayer, bottom 10th
This is
line.
arithmetic.
My lord,
This is not arithmetical correction.
my lord.
This is typographical correction, or
Typography-
at most numerical correction. Arithmetic would involve a process
My lord.
of application of mind.
My lord.
Yes, what do you say?
Typo.
Typo. But where is the order? Oh, in the order, in the writ petition you want
In
to?
the petition.
Okay,
The review petition.
review petition.
My lord.
Okay, we allow this.
Fine.
Okay. Heard Sri M.A. Sikh, learned counsel for the applicant oblique review petitioner, who by means of this application has prayed for allowing corrections of the corrections appearing correction in the following manner, huh? Paragraph 3.
Corrected as
Puस्तक.
eto.
Also heard Sri Ardhar. Yeah, for the state council, London State Council, who does not object to the said.
Only one confusion. Just if the date is corrected, whether, my lord, in the writ petition, was this a review petition, my lord? The writ petition also, my lord, gets disposed of.
We'll consider the review. Whatever is there on the writ is gone. Who does not object to the aforesaid prayer. Full stop. He has, however, submitted that the writ petition, that the order passed in the writ petition has attained finality. Correct? Considering the above, comma the instant petition for correction, in the review petition number 244, 2025, as indicated above, is allowed. Full stop. I stands disposed of. Para. Petitioner, learned counsel for the petitioner is required to file a corrected review petition in terms of the order passed today.
Obliged.
Three, last negative. Yes, what is this?
My lords, this is a writ petition. My lords, before I start, can I humbly request your lordships to take up 3 pleadings and just keep them on the side because it will be easier for your lordships to follow my arguments. My lords may take up my writ petition. My lords may take up my rejoinder. Directly open page 404 and keep it ready.
What is your case first? Let us know your case.
Yes, my lords, I am L3. Respondent number 1 is PWD.
No,
Respondent
no.
number 2
You
is
start with the fact. There was a tender notice or what?
yes. So my case.
Who had floated?
Sorry, my lords.
Who had floated the tender?
PWD had floated a tender.
Public Works Department had floated it.
Correct.
Please go chronologically, Mr.
Sure, my lords. Sure, my lords.
PWD had floated a tender for
Yeah.
what?
Construction of a circuit house, my lords, in Udalguri. The tender was floated on 29/7/2025.
29/7/25
Correct.
for circuit house.
Yes, construction of a circuit house in Udalguri.
At Udalguri.
Right,
Okay.
my lords. On 8/8/2025, the joint inspection took place by respondent number 3 and respondent number 4, both the private respondents, under clause 6(1) of the tender document. On 14/8/2025, a very, very important date, PWD certified this joint inspection, my lords. Now, I submitted my tender on 21/08/2025, 21 August 2025.
21/8.
Right, my lords.
You submitted your bid.
Right, my lords. I submitted my bid on 21/8/2025.
Yes.
Respondent number 3 submitted its bid on 22/8/2025.
Mm.
And similarly, around the same time, respondent number 4 also submitted their bid,
3 and 4.
3 and 4. The technical bids were opened and admitted on the same date, this date being 28/8/2025. My lords may note the page number for this.
Technical bids opened.
Yes, opened and admitted at page 70 of the writ petition, 28/8/2025.
Yes.
Now, there was a gap between the time the technical bids were opened and they were evaluated. The evaluation, my lords, took place on 24 October 2025.
Evaluation of technical bids.
Yes, yes. I was informed that I have been qualified technically on 24th of August 2025 at page 71 of the writ petition.
You are found to be technically responsive.
Responsive. Yes, my lords. On the same day,
Yes.
the financial bids were opened, lightning pace, no opportunity given for any bidder to raise any query between the technical and the financial round. On the same day, at page 73, the financial bids were opened.
24/10.
Yes, my lords. I was declared as L3. Respondent number 3 was declared as L1.
The petitioner is L3.
The petitioner is L3.
Respondent
Respondent number 3 is L1
L1. Then
and respondent number 4 is L2.
okay.
Right. My lords, may I kindly have page number 74 of the writ petition. This is where my case lies.
Yes.
Before I actually proceed with the case, my lords, can I just kindly read the first 2 interim orders passed by this honorable court?
You place the facts.
All right, my lords. Page 74 of the writ petition, my lords.
Yes.
I am essentially alleging violation of clause 22B at page 74 of the writ petition. My lords, may please take up page 74. Sorry, my lords, page 47. I'm really sorry, my lords. Page 47.
47.
Right.
Just a minute. Yes. Which one?
So, my lord, page 47 basically has an integrity agreement, as
Yes.
my lords will see at page 47,
Yes.
that every prospective tenderer had to submit as a part of their bid.
Hmm.
Now, this integrity agreement is basically a warranty of integrity that every tenderer has to submit to the authority.
Yes.
At page 48, my lords will see Article 2, commitments of bidders.
Yes.
These are highest assurances that they will not indulge in any act of corruption or collusion and uphold the sanctity of contracts.
Hmm.
My lords will see Article 2(2)(b). According to me, this is the clause that is getting violated in this case, and I will demonstrate how.
2(2)(b) is at page 49.
2(2)(b) is at page 48.
48.
I may, if with your permission, I will read 2(2)(b).
2(2)(b).
B.
Okay.
Yes.
Okay.
The bidder/contractor will not enter with other bidders into any undisclosed agreement or understanding, whether formal or informal.
Hmm.
This applies in particular to prices, specifications, certifications, subsidiary contracts, submission or non-submission of bids, or any other actions
Not to form any cartel.
Yes, yes. My lords, if my lords will just kindly take up my reply at page 404, I have given my detailed interpretation of this clause. Once I place that, I will then place the facts. My lords, may kindly take up page 404 of my rejoinder.
Now, place the facts.
Yes,
first,
yes,
Then
ma'am.
you can come to your submission. Please, that what had happened? How is
My
it
lord,
violated?
The allegation is respondent number 3 and respondent number 4, in violation of this particular clause, have gone to the site together, have carried out the site inspection together, have taken a photograph at the same time, at the same place, and submitted the same photograph as a part of their individual bids.
Yes.
And this exercise has been mechanically approved by the PWD for reasons best known to the PWD. To demonstrate this, I will take your lordships to 4 pages. My lords, may kindly take up page number 58 of the writ petition.
5-8.
5-8. So 5-8 basically is a part of the bid submitted by respondent number 3. 58, at 58, my lords will see a site inspection report dated 14th of August 2025. This is a part of the bid submitted by respondent number 3. This is to certify, and this has been certified by the PWD. This is to certify that Shri Biplab Doimari, representative of Allied Construction, has visited the site along with Digonto Borua, assistant engineer for the work of construction of new circuit house. So the impression one gets when one reads this document is that respondent number 3 visited the site with a representative of the
Biplab
PWD.
Doimari is R3.
Sorry, my lords.
Biplab Doimari is R3.
Yes, Biplab Doimari is R3.
Oh,
Correct.
means Allied is R3.
Yes, my lords. Yes, my lords. My lords may now kindly turn over leaf. So this is the photograph that has been submitted by Allied Constructions.
Yes.
So when I read 58 and 59 together, the impression that I get is one person is from PWD and one person is Biplab Doimari necessarily.
Yes.
Now, my lords, may please kindly turn to page 68.
Yes, please.
At 68 is the site inspection report submitted by R4. Same day, 14/8/2025.
R4, yes.
Here also, similarly, the PWD has certified.
Puja is R4.
Yes, Puja is R4. Here, PWD says that Puja has visited the site along with Digonto Borua. Now, my lords, will see the photograph at next page.
Yes.
69 is the photograph submitted by R4, Puja Associates.
Okay.
The photograph at page 69
Yes.
is identical to the photograph at page 59. My lords will see that both the photographs were taken on 8/8/2025 at 16:32 p.m.
Yes.
Geotag locations. There can be no manner of doubt that there is any discrepancy in this.
Yes.
So the impression that one gets when one reads these photographs in conjunction with the site inspection reports is that one individual is from PWD and the same person has represented both R3 and R4. So when I had the opportunity to look at this, and according to me, this was a glaring inconsistency and directly fell within the ambit of an undisclosed understanding qua certification under clause 2(b), I pointed this out through a representation on 25/10/2025. That representation, my lords will see at page 74 of the writ petition. I said, look, this can't happen.
74.
74. This is my representation that I had filed with the PWD before I filed the writ petition. In this representation, I detailed as to how this is in gross violation of 2(b). This is in gross violation of the integrity pact that every bidder has to essentially submit. This is in gross violation of clause 2 of the tender document, which broadly bars joint ventures. No response was received. When I pointed this out to the writ court, they have now changed their stance. So my first submission is, the PWD, after it was confronted with these facts before the writ court, has now changed its stance from 14(8) to what they say in their affidavit in reply. My lords, please take up page 360 of the affidavit in reply. My submission is that they are trying to improve their case from 14/8/2025, something that is absolutely impermissible as per the Constitution bench judgment in Mohinder Gill Singh. Please take up page number 360 of the PWD's affidavit in opposition by respondent number 1.
360.
Yes. So at first they say that the PWD engineer was present. My lords have seen that at 58 and 68. Now I am going to read paragraph 7 that starts at 359. And with your lord's permission, I'll read the entire paragraph because this is extremely important according to us.
Please.
That with regard to the statements made in paragraph number 9 of the writ petition, the deponent begs to state that the site visits were allowed for all bidders without restriction on timing. Both the respondents visited the site on the same day, admission number 1, as reported by the engineer in charge. The EIC was sought clarification on the matter. Accordingly, he has clarified that the geotagged photographs submitted by the two bidders are not identical. Absolutely false. We have seen how the photographs are identical. Now, this is very, very important. And the representative of bidder Allied Construction, Mr. Biplab Doimari, and bidder Puja Associates, Milan Doimari, are distinct individuals. They had jointly visited the site and took photographs together. Specifically, Biplab Doimari, representative of Allied Construction, appears on the left side, and Milan Doimari, representative of Puja Associates, appears on the right side. A U-turn taken by the PWD in this writ court. So this U-turn has two implications. Number one, this U-turn is a change and improvement in the case from 14.8, which as per law is impermissible. But I will proceed with the assumption that this is the correct
No,
state of
in
facts.
the initial stage, was it asserted that one individual, one officer of the department was also in the photograph?
Yes, 14.8.
No, no, let us see what is the averment.
My lords may take page 58.
58 is your averment.
No,
Is-
58, my lords, is the site inspection report certified by the PWD.
Let us see.
Yes, my lords.
58.
Yes. This is not my document, my lords. This is the PWD's document.
I have it. Let us see.
58 of the writ petition, and my lords may in fact have 360 side by side. This is to certify that Sri Biplab Doimari, representative of Allied Construction, so and so, has visited the site along with Assistant Engineer Digonto Borua for the work of construction of new circuit house.
Yes.
So this is, my lords will see, this document has been signed by the Executive Engineer, PWD, Udalguri, Baskar District, so and so.
No, this will not necessarily mean that this Digonto Burua of the department is featuring in the photograph.
No problem. No problem. Let us assume that notwithstanding this change of stance, let us assume that respondent number 3 and respondent number 4 went together.
Yes.
What is admitted is
Yes.
they went together.
Yes.
They jointly inspected the site. That
Correct.
is admitted.
Mm.
They took a photograph together. That is admitted. So the
Yes.
question now before your lordships is this sufficient to attract clause 2(b)? If I'm able to convince your lordships
Yes.
that this is sufficient
Yes,
to
yes.
attract clause 2(b),
You address on that.
yes. For that, my lords may please take up page 406 of my reply.
406.
406. According to me,
Just
what-
a minute. Just a minute.
yes,
40.
406 of my rejoinder. And I'm going to read a few paragraphs because these paragraphs are self-sufficient in terms of explaining my case. And my lords may have the clause side by side at page 48.
406. Please read.
Yes.
406.
Clause 2(b) prohibits bidders from entering into any undisclosed agreement or understanding,
Hmm.
whether formal or informal, particularly with respect to inter alia certifications. So
Yes.
if I'm able to establish before your lordships that some undisclosed informal understanding has been entered into with respect to certification, this clause is retracted and the consequences of disqualification ought to follow. Now, this clause, my lords, if my lords will see this clause, keeping in mind the general objective behind this clause, which is to uphold the sanctity of public contracts, is very broadly worded. It includes any and every act of collusion within its ambit so that the integrity of the tender process is not compromised.
Yes.
For this very reason, this clause does not envisage the furnishing of any direct proof of collusion. My lords, collusion never happens on paper. Collusion is never a determination, is always an inference, I would submit. So this honorable court will have to infer from the photographs whether a case of collusion is made out. Even entering into an understanding which cannot be proved by direct evidence is sufficient to attract collusion, according to me. This understanding, the clause itself says that this understanding need not be formal. It can very well be an informal understanding which necessarily has to be inferred from circumstantial evidence. This clause applies to certifications like the joint visit certification in the instant facts. So this is how the clause is very, very broadly worded to include any sort of understanding. It could be a clandestine understanding also.
Hmm.
Now, my lords will take up paragraph 10. Paragraph 10 at page 407.
Yes.
Respondent number 3 and respondent number 4 visited the site together. The fact that they say it was coincidence, which is the stand that they have taken up in their reply, is purely immaterial for the purpose of clause 2(b). The fact that the express requirement to submit a photograph was not a tender condition absolutely makes no difference to the otherwise applicability of clause 2(b) if based on such photograph a case of collusion is made out, which is my case.
Good. Fine. Fine. So we'll continue at 2 o'clock. I think this is running late.
Please, my lords.
When? Mr. Mohanta has done some mischief, it seems. Manipulation of watch. That too court watch.
Just planning his.
See, he is also supporting. Okay, at 2 o'clock. Maybe after 2:10 around. Okay.
Please, my lords.
Very well.
But that will take time. How long will you take, Mr. Goswami?
5 minutes, Lord.
Hmm?
Because,
Yours is a motion matter.
yes, my.
Okay. Mr. Chaudhary, just wait for a while.
Sorry.
Yes. Got the instructions? Hmm.
I question the maintainability of the referee. But it's a pure question of fact.
Now, have you been instructed to appear?
I have been.
Then, okay, then you can issue notice
Very well,
at
Lordship.
this stage.
Yes.
You don't know. What are you challenging, Mr. Goswami?
Lordships, I am basically challenging the unilateral decision of the respondents in changing if Lordship will come to page 30. Every vendor code has certain details attached to it.
Correct.
Like in respect of against my vendor code,
Hmm.
initially I had the State Bank of India account attached, my GST number and my PAN card, which has now been changed by them.
Why have they changed?
Yes, why
Why?
have they changed is very interesting, Lordships. Initially, I was a proprietary firm, which the proprietary firm still continues.
Hmm.
The privity of contract is between the proprietary firm and ONGC. In 2023, I did make a partnership firm with two other gentlemen, the Mascaras.
And this, you're praying for a stay of 4625.
Yes.
What is the implication of 4625?
Lordship may not, at this moment, may not.
Then we'll issue notice, let you take
Yes,
instruction.
yes.
Heard. Sri M. Goswami, London Senior Counsel, assisted by R. Chaudhary.
Yes.
Full stop. The petitioner has put to challenge the action of the respondent corporation, which has been termed to be unilateral in changing the status of the petitioner from his individual proprietorship capacity to
Partnership.
partnership. Full stop. It is submitted that such action would have adverse ramification, and without giving any notice, the same has been done. Full stop. He has also added that no reasons are prescribed.
In fact,
For-
they have not even responded to our notices.
No reasons have been prescribed, nor any reply made to the
Legal notice.
query made by the petitioner regarding such change. Let notice be issued, returnable. We give a date, Mr. Goswami?
30th January, so convenient for your Lordships.
30 would be, I think, short. Can you take 30? 30, is it okay?
30 January.
Affidavit before that.
Because the point is very short, Lordships.
We have
Ultimately,
it on 9th of February, is it okay?
very well, Lordship, whatever.
9th of February. Sri P. Borwa, Learned Counsel, has submitted that he would accept notice on behalf of the respondent number 1. Let extra copy be served upon him. By the next date, Sri Borwa is required to file the necessary power. Steps for service of notice upon the respondent number 2 by registered post by speed post PTD. Steps will into this.
I'm very grateful. Great.
Why have you made party by name? Number 2?
Number 2, why have you made a party by name?
Because he was the one who's the one.
Are you
So-
alleging any malafide against him?
No, but yes, the Dole, no? Yeah, Dole, yes, we are because.
You're alleging
Yes,
malafide?
yes, yes.
Okay.
He is the person who's creating the problem. I'm very grateful. Grateful. Thank you for accommodating me.
Yes.
Yes, my lords, as I was submitting before the lunch break, my case before your lordships is that respondent number 3 and respondent number 4, in jointly inspecting the site and submitting those photographs as a part of their respective bid,
Correct.
attracts unilateral and undisclosed informal understanding qua certification under 22B. I was reading, my lords, my arguments in this regard at page 408 of the reply. If my lords may kindly take up the reply. I'm going to finish very brief soon, just after reading these arguments. My lords, I had indicated as to how the clause is very broadly worded to include any and every act of collusion. I had also indicated that corruption or collusion or cartelization by nature does not happen on paper. It necessarily has to be inferred. It is my case that the mere presence of these two bidders together is in itself sufficient to attract collusion. because the contract is very clear, my lords, that two bidders could not have been seen together, which is why the whole integrity agreement was in place to ensure that when they are submitting their bids, they do that in their independent capacity. Now, my lords, will take up page number 407, paragraph 10, where I explain as to how the actions constitute and draw the clause. Respondent number 3 and respondent number 4 visited the site together. The fact that they say it was a coincidence is completely immaterial for the purpose of 22B. The fact that the express requirement to submit a photograph was not a tender condition makes no difference if otherwise the case is made out. Respondent number 3 and respondent number 4, after visiting the site together, took a photograph together. This is admitted. There is no dispute on this. In fact, they have subsequently changed their stance. This is important, my lords. The identical timestamps on both the photographs are objective indicators of coordination. Otherwise, there is no reason, my lords, for respondent number 3 and respondent number 4 to take a photograph together. The integrity agreements bars such kind of informal understandings as well, and they are not just limited to formal agreements. Both respondent number 3 and respondent number 4 have made this photograph a part of their bid in furtherance of site visit / verification. When both the photographs are seen, the impression that one gets is that both the individuals inspected the site together and took the photograph in furtherance of such inspection. In other words, the same photograph was relied upon as independent certification by the two bidders. This is my case, my lords. There was no reason for two independent bidders to have produced identical certification material unless there was a prior understanding or coordinated effort between them. And to add to this, the bids of these two bidders containing the same photograph was mechanically certified by the department on the same day. My lords, these were submitted to the department on 8/8/2025, much before the technical round, in fact, had started. It was incumbent on the department to identify these and question them. They did not do so. Nothing was done until we had filed this writ petition, my lords. The upshot at page 409, para 11, the upshot of the above discussion, according to the petitioner, is that respondents number 3 and 4 shared and relied upon a common certification exercise, defeating the requirement of independent due diligence and independent bidding. This, according to us, my lords, constitutes a classic case of collusion. A shared site inspection and shared evidentiary material is functional collaboration, even if not expressly labeled as a joint venture. This is equally prohibited under 2.2 because no plausible explanation has been given by any of the respondents to demonstrate as to why this photograph was taken in the teeth of the express language of clause 2.2b. In their reply affidavits, they all say that they had taken the photograph. No plausible explanation as to why this photograph was taken. My lords, an integrity agreement is not just a mere formality. My submission is that an integrity agreement goes to the root of the tender. And while evaluating whether a case of collusion has been made out or not, your lordships will have to read between the lines and see whether, on the basis of the circumstances, a reasonable third party, according to that reasonable third party standard, an impression is formed that these two bidders had some sort of understanding before the contract or while in the process of submission of the bid. If that is so, it is my submission, my lords, that 2.2b is attracted, and the consequences of that is prescribed by Article 3 of the integrity agreement, which is disqualification. It is also important to mention that the entire integrity agreement, being an essential tender process, cannot be allowed to be diluted. My lords, the Supreme Court has repeatedly held that these are strict tender terms. Like penal statutes, they have to be construed strictly. In fact, the use of the word shall and will in the integrity agreement also indicates that these are mandatory obligations that ought to be complied with. I'm going to finish, my lords, with two submissions. In addition to all of this, my lords, there's one more point that your lordships will have to consider. This is not the only time L1 and L2 appear to have bid together. In my affidavit in reply, page number 412 onwards, I have annexed at least 3 or 4 tender documents where L1 and L2 have somehow appeared as L1 and L2 in all of these contracts. My lords, will please see page number 414, for instance. These are all separate contracts, not related to this particular contract. But they seem to always emerge as L1 and L2. This is a pattern, my lords. I am not saying anything. I am not determining anything out here. I am simply placing this for your lordship's consideration. The point being, this is not the first time L1 and L2 have participated in the same tender and have emerged in these respective positions. In fact, this honorable court, my lords, this case has traveled to your lordship bench from your previous bench. The previous bench has already formed a prima facie view. If I may just place those two paragraphs before I finish my arguments, my lords. My lords, kindly take up the second order. Order dated 12/11/2025. 12/11/2025. It is the second order. The first order had had granted an interim protection in my favor. The PWD was directed not to proceed with the tender. In the second order, I'm placing paragraph 2. If my lords have it, I'll place it.
Yes.
This court has perused the records, including clause 6.1 of the tendered conditions. From a perusal of the records, the allegations which have been made by the petitioner insofar as submission of the same site visit certificate by both respondent number 3 and 4 appears to be prima facie correct. It is a prima facie view, no doubt. But nonetheless, a view has been formed by this court that these allegations are correct. Paragraph 3 is even more important, my lords. This court inquired with Mr. B. Chaudhary, learned senior standing counsel for the PWD department, as to whether one of the respondents should not be debarred, taking into account clause 6.1 of the tender conditions, which mandatorily requires bidders to visit the site. Apart from that, the other bidder has violated clause 2(2)(b) of the integrity agreement, which stipulates that there cannot be any cartelization with respect to certification. So, in addition to this honorable court already forming a prima facie view, in submission, in conclusion, it is my submission that whether there is actual evidence of cartelization or not is something that we will never get to know. Because like I said, corruption always happens in the clandestine manner, which is why these assurances and these warranties become extremely important. Perhaps if the photographs were not submitted, we may have never got to know about this. I agree on the flip side. But now that the photographs have been submitted, it has to be seen whether the submission of these two photographs, the joint inspection carried by respondent number 3 and 4, constitutes a joint certification under 2(2)(b). In my humble submission, it does, and the consequences, my lords, ought to follow. My prayer is threefold. Number 1, please disqualify L3 and L4 on account of violation of clause 2(2)(b), read with clause 2 of the tender document, which generally debars joint ventures. Number 2, I have instructions, subject to your lordship's satisfaction. I have instructions to submit that I am, if your lordship is convinced that a case has been made out, I am willing to do the works at the rates prescribed by L1. And my third prayer is, my lords may direct a quash this tender and direct a retender. These are my submissions, my lords. My submissions are very simple. They are primarily based on these two photographs. In my understanding, the fact that they went together, they have not denied any of this. And submitted those two photographs as independent verification constitutes joint certification that is expressly barred by 2(2)(b). With this, I rest my submissions, my lords. My lords, my reply, my rejoinder is crystal clear on all these submissions as well, my lords.
Yes.
Lordship, I'm not going into the facts since my learned friend has already.
Yes. You appear as CPWD. SCPWD.
Lordship, may kindly take up the additional affidavit, page 122.
122.
Yeah. The seat from which this repetition has evolved, Lordship.
Yes.
Lordship, clause 6. What does is the requirement and terms and condition of the tender? Site visit, Lordship.
Yes.
The bidder is advised to visit the site of work mandatory at his own cost and examine it and its surrounding to collect all information that he considers necessary for proper assessment of the prospective assignment. Site visit by the bidder is mandatory as the site is full of number of existing structures. Lordship, this clause emphasizes that whoever may be the bidder, he has to visit the site. Nowhere, Lordship, requirement of photograph geotag is stated, nor in entire terms and condition of the tender, Lordship, there is any bar for attaching a photograph. Now the second question comes, Lordship, why the two bidders photograph themselves jointly? Lordship, in such kind of tender, Lordship, there may be number of bidders and they may visit the site within 1 or 2 days. And it is not that only one can go there in 1 day and the assistant engineer or whoever may be the representative of the department has to go every day, Lordship. Nowhere in the tender condition there such type of restriction has been given. Lordship, they may have appeared jointly, but everything will depend upon their technical capability and financial assessment, evaluation. by the authority. And as they have submitted the two photographs, joint identical in nature, in their bid, Lordship, the authorities sought clarification from the engineering itself. And Lordship, that I have already explained and annexed in the, in my affidavit. Lordship, that is in page 379 of this, annex 4. Lordship, here the additional chief engineer PWD building has wrote to the executive engineer of Udalguri and Buxar districts. With reference to the above, the bidders, Pula Associates and Allied Construction, who have participated in the tendering process for the Udalguri circuit, submitted visit reports along with photographs bearing your signature. However, it has been noticed that the photographs submitted by both bidders are identical. In this regard, you were kindly requested to confirm the authenticity and genuineness of the site visit photographs of the bidders and the letter issued from your end. Your early response in this matter will be appreciated for taking further necessary action from this end. In the next paragraph, Lordship, the clarification has been given.
Next page, next page.
Next page, Lordship, the clarification has been given by the executive engineer. With reference to the subject cited above, I would like to state that the two representatives of both the bidders took photographs jointly. The Biplab Dharmari, representative of contractor Allied Construction, is in the left side of the photograph, and Sri Milan Dharmari, representative of the contractor, is on the right side of the photograph provided. Though in the certificate it was mentioned that contractor represented the site along with the assistant engineer Diganta Borua, but he was not in the photograph. Lordship, there has to be someone who has to take the photograph. It was the engineer, Lordship. And secondly, Lordship, the allegation that has been made that it was an afterthought. Lordship, records will reveal that before opening of the financial bid, the additional chief engineer sought clarification, the letters that I have annexed from the executive, because it was not a requirement of the tender condition. Even then they have given it. So there has to be some clarification, and Lordship, the records will reveal that was not taken into consideration, the photograph. Simply it depended upon the technical evaluation and the financial assessment of both bidders. And there was nothing on record to show that some joint cartel or was done between them. And neither in the tender bid documents submitted by each of the bidder, nothing document reveals such type of nature of bidding. Therefore. And Lordship is well, I'm not going through the judgment. Lordship, it is the maker of the document who is the best person to interpret the condition. And since they fulfill the every other condition, Lordship, and it was within the requirement of the tender condition, they were given the bid. They were evaluated as L1 and L2, Lordship. Lordship, may kindly take up our affidavit on page 358. Lordship, where in paragraph 5, 6, and 7, we have explained our position.
Page?
Page 358.
Yes.
Lordship, paragraph 5, that with regard to the statement made in paragraph number 7 of the repetition, the respondent begs to state that there is no proof of cartelization or joint action in the bidding process or the documents submitted by each of the bidders. Both respondents complied fully with the terms and conditions of the bidding document. The condition of restriction on bidding by joint bid venture in the said tender process has not been found to be violated, as no joint bid was received by the department in the said tender process. Each bidders maintains separate technical and financial credentials. Similarities in documents or timing do not imply collusion, as evaluation was completed in a transparent manner on the basis of their credentials, and accordingly L1 and L2 were determined on merit. And in paragraph 6, logic, with regard to the site visit logic, that with regard to the statement made in paragraph number 8 of the writ petition, the respondent begs to state that the integrity agreement dated so and so were executed separately by the respondent number 3 and 4 respectively. Each agreement bills the respective bidders independently. Tender committee found all documents in compliance of the condition, and there was no breach of irregularity noted. There was no proof of exchange of confidential information, coordination in bid pricing, or restriction of competitiveness. And in paragraph 7 logic, we have explained how the clarification was sought from the executive engineer. In my humble submission logic, the petitioner has not been able to show anything that makes a nexus with the object between the respondent number 3 and 4. Then that they have jointly done something which is against the clause 2(b) of the integrity agreement. Lordship, only on the basis of the photograph jointly taken, that cannot be a ground for quashing the tender bid, because Lordship has seen the clause 6. It does not ask for giving a geotag photograph. They may have given it, Lordship, no doubt, and jointly taken, but that was not taken into consideration, which will be revealed from the records, Lordship. I have the records, Lordship, I can produce it.
No, if the photograph as you have submitted was not one of the relevant factors which was taken into consideration to come to a satisfaction that this particular clause has been satisfied by Mr. Mohantas and Mr. Poddar's client, how did you arrive at a satisfaction that this clause, mandatory in nature, was fulfilled by both the private respondents? On what materials?
Lordship,
From the certificate.
Certificates and the annexure 1, Lordship will find all the condition evaluation 6, Lordship. From that, it came to a prima facie satisfaction that all the conditions were satisfied, and this was done on it was done before, after the clarification was sought for, because the clarification with regard to the photograph that came into the bid evaluation committee before the bid evaluation committee, and they accordingly sought for the clarification, and the evaluation sheet will reveal everything that the terms and condition of the NIT has been fulfilled. And Lordship, the minutes will also reveal that the photograph was not taken into consideration. Only on the basis of their credential, both technical and financial, the departmental bid committee came to the final conclusion.
No, that is where repeating the question. There is a requirement for a mandatory site visit.
Yeah.
Now, that requirement, the responsibles 3 and 4, they claim to have fulfilled. How did you get yourself satisfied that this mandatory requirement was fulfilled by them? Was it on the basis of the photograph?
No, basis of the certificate.
By the executive engineer?
Yes. The photograph was not taken in, though they have annexed it, so that clarification was sought for. Lordship, I have read it, and that was not taken into consideration.
Okay.
And if Lordship required, I have the record. Lordship.
Oh, we'll see the record. Yes, Mr. Mohanta, for whom?
whole basis of their case is my lord photograph. That it is filed with the rule, clause my lord, that my lord, there is a curtailment, there is a understanding, there is a.
Yes, interns, why did you take a seat? Why are we standing? Sit, sit. Chairs are vacant.
So your lordship kindly see that their whole argument is that, my lord, from that photograph in fact that there is a understanding, there is a secret agreement. That is presumed that is my lord conferred. Your lordship kindly see. When they were argued the case before this honorable court, projected a different case, and today they have argued that it's a different case, my lord. While they were arguing before the court, my lord, I was not there, but the order reflect, my lord. They got the stay order by giving a statement which is not correct. Your lordship kindly see the order dated, my lord. 7/11/2024. 7/11/2025. They projected the case.
Just a minute.
7/11/2024.
First order.
The first one.
Yes, let us see.
They stated the representative of both, my lord, petitioner number, respondent number 3 and 4, they are the same in one person. That is that they have their argument before this honorable court.
Where do you get it?
Page 6, para 6, my lord. Para 6 of the.
Hmm.
The learned counsel for the petitioner
Oh.
therefore submit that it is the same person who has represented the both the respondent number 3 and 4 who carried out the verification. My lord, it is a coincidence, my lord, because your lordship kindly see the site visit is mandatory, but giving photograph is not mandatory. But we have visited, my lord, it is when we visited, that clause is why clause is required. Clause is it is actually just to that so that, my lord, in future the person who get the contact, he cannot say that this is not the site. We cannot the site which was you have spelled out in the tender notice that is not the same. So that is the reason, my lord, that is the site verification is required. So site verification in every tender has to be visited, and that has to be certified by a inspector, certified by engineer, my lord. So when 4-5% jointly, my lord, same day visited in the coincident, then they have taken a photograph. That is, my lord, annexed. So, my lord, can it be, my lord, from that photograph it is conferred, my lord, conferred that, my lord, presume that, my lord, there is a curtailment, my lord. Your lordship kindly see. Rather, it is safely your lordship can presume that it is bona fide that there is no any under agreement, my lord, because we have annexed it just to prove it, my lord, before our innocency, my lord. If we have, my lord, that is meaning that there is any curtailment, then why should I annex it, my lord, in the tender paper, my lord? So in other way around, your lordship can presume, my lord, because their presumption is that they jointly visited, that is why there is a curtailment. I say yes, that is absolutely incorrect statement, my lord, because they are projecting that the same person visited on in behalf of the same company, to both company. That is, there is a curtailment, my lord. Then I do not deny. But it is not that, my lord. Two persons from the two different, my lord, respondent number 3 and 4, different company, they, my lord, visited, my lord, and there is a photograph taken by the engineer, and they have given a certified, my lord, and that, my lord, certificate is enough. But even then, my lord, we annex it, my lord. Annex it, my lord, in the tender document. So they projected their case, and the same photograph, obviously, my lord, when the joint photograph been present, so your lordship kindly see the photograph. That is Doimari, and another is, my lord, I don't know his name, my lord. One is Doimari. Doimari is the representative of, my lord, respondent number 3, and he is, my lord, white shirt, and it is, my lord, other, my lord. So they are two different persons, but they are projecting the case, my lord. Otherwise, my lord, on the last occasion, my lord, yes, court has said, yes, you have projected that case as the same person, my lord, visited on behalf of the same company, two company. Otherwise, no, there is no stay order passed by this honorable court, my lord. In fact, in the pleading also, that one and same person they have said. It is not correct, my lord.
Let us see. Where?
Your lordship kindly see. That is the submission made before this honorable court, my lord.
Not
On the
in-
basis of that submission, my stay was granted. So your lordship kindly see, Pella, my lord. Para 9, my lord, your lordship kindly see. So the petitioner submit that the above became clear that the site has your lordship ordered. two person in this photograph are one and same. That is their pleading, and that is the argument they have made. The one person visited on behalf of the Buddha. So my submission before your lordship.
No, in the pleadings, they have not said so. They have presumed that one of the persons is Diganta Barua.
But
The-
they have made a statement submission before the court. They
Sub-
obtained the stay order, my lord, on the basis of that.
That we have
But
noted.
but no, that they
That-
reflected. There was the expert order. When I appeared, I pointed out. Then court has yes, then I see because I have seen that the record was produced and record that both the photographers, yes, both the photographer annexed by the both the expert number 1 3 because since it's a one photograph. So that does not mean that, my lord. So if, my lord, there is a secret understanding between these two parties, then why they will annex it, my lord? From that, my lord, your lordship can safely presume that there is no curtailment. Only because of that photograph there is a curtailment. It is open tender, my lord. We are L1, I am the L1, my lord. So my submission before your lordship, because of this, my lord, that photograph that cannot be my conferred that there is a violation of the clause, my lord. And my lord, another, my lord, maybe, my lord, in another open tender, my lord, maybe L1, L2, my lord. That does not mean that, does it mean that, my lord, there is a curtailment, my lord? The curtailment, there is no definition in any way except in the Competition Commission Act, my lord. There is a curtailment. When there is a, my lord, there is a several procedure is there, my lord. Your lordship will get only that kind. But it is actually, my lord, if there is another irregularity is there, then everything is all right, my lord. But there is no only the photograph. They have stated that only the photograph. So my submission before your lordship, there is no violation of the clause that's 2.2. So my lord, and they obtained the stay order, giving a statement which is not correct. So I strongly, my lord, that is because that was I pointed out before this honorable one last occasion. They have said, oh, I thought that it is the same person. That is not same person. So that is crystal clear. Because your lordship kindly see that that is already my learned friend. My lord, my para 8 is, my lord, everything I have explained in my para. And he has taken part in the petitioner, taking part in the proceeding, my lord. After knowing that, my lord, he came before this honorable court. He is not the L1, that's why he came before this honorable court. That is then whether, my lord, this condition or everything, sir, my lord, correct or not, that the right person to the, my lord, judged by the authority concerned, my lord. That is the, my lord, the law passed by several law from right from CCL to, my lord. My lord. Right from Jagdish Mandal to, my lord, CCL, your lordship kindly right placed, my lord, CCL, my lord, para 47. Para 47.
Central Coal, what is the citation?
16.8 SCC 622. 2016-8 SCC
Yes,
22, para 47 and 47.
47.
40.
47 and 48.
So that's my submission, my lord. Your lordship kindly see that. In fact, that photograph, my lord, shows my bona fide.
Mr. Poddar, Mahanta for R3.
And just there is a certificate.
Here for R4, R4, L2. L2, L2.
Annexure B at page, so form H, annexure 135.
Annexure 130,
135.
page.
Additional affidavit, okay?
Mhm.
Form H, it shows the declaration about the citing. Okay, this is the mandate.
Proforma. Page 130.
5. This is the mandate part of the tender. The declaration of citing and the purpose only that we cannot claim regarding any defect in the site, lowland, etc. So this is the only object of the site visit declaration. So for other point is concerned, in the last
So far, they have given the additional affidavits in the last part regarding the two other tender documents regarding showing L3 and L4. It is open tender, also some other firms, they have annexed the document also. In one tender, JCL Infra has taken part, in other tender, two other companies have taken part. So these are open tenders also. It shows rather we are competing each other. We are competing each other, not fertilizing. And in both these second tender, the L1 will bring the works to the certificate department. The allegations what brought fertilization is totally lordship false. These are an open process. We have taken part. We have given our bid. Technical bids were opened 2 months back. Then the financial bids opened after 2 months. So they have no case now. That is.
But technical evaluation was done on 24/10, followed by opening of financial bid on the same date. 24/10, same date.
Yes, my lords. They have tried to conflate the dates.
Will come to. 20. Okay, 28/8. Technical bids were opened and it was found to be responsive on 24/8/10/25 and same date on the date of opening of the financial bids. Okay. Anything else?
No,
Mr. Yes, short reply,
Short reply, my lords. I'm extremely grateful my learned senior friend brought up paragraph 6 of the first order. In my writ petition, I did submit it was the same person, but on what basis, my lords? It was on the basis of the certificates. It was on the basis of the certificate that the PWD gave, where they said that Digonto Borua was present with the representative of R3 and R4. So when I did not have the benefit of the change in stance that they have subsequently taken, any reasonable third person, the inference that one will draw is that one person was Digonto Borua and the other person was the combined representative of R3 and R4. And I made this submission before this honorable court also. Notwithstanding, without prejudice, this is incorrect. My submission still remains that the mere presence of these two people attracts 2-2B. The fact that they have produced this.
That submission you have made.
The fact that my extended submission is the fact that they submitted these photographs is not bona fide, it's foolishness. Because the clause is very broadly worded. Presence is sufficient because undisclosed and informal understanding includes within its ambit presence. There was no requirement for them to click a photograph together. When the Council of PWD here states that Digonto Borua took that photograph, and when L2 here openly declares that L1 has done the work satisfactorily, these are extremely important considerations for your lordships to necessarily infer collusion.
What work has been done satisfactorily? Who has said?
Right now, my Mr. Podar, my learned friend, no, he literally right now said that L1 has done work satisfactorily. I see no reason why L2 has to complement L1.
No, that is not his submission.
Whatever may be the case, L2 complementing L1 is a very problematic statement.
No, he has said that rather it shows competitiveness. They are competing against each other.
I am saying that there is a pattern of these two bidders emerging as L1 and L2 together in multiple contracts, and that is a point for your lordships to consider. I am not determining anything. Lastly, on maintainability, unfortunately, and with the greatest amount of respect, I will submit that the understanding on this part of this part is rather rudimentary. This is not a case where I have challenged the tender clause because I have lost. This is the case where I am alleging collusion. That does not bar me from filing a writ petition in this honorable court. That's all, my lords. My submission has all throughout been the fact that they visited the site together is sufficient to attract 2-2B. I rest my submissions.
Okay. Well, we could have dictated, but there's a reference to rise early today.
My lord, I just want to point out one thing. May not be relevant. My lord, we just take a look at the affidavit and replies filed by L1 and L2. They have not just the first page is good enough. The affidavit in replies filed by L1 and L2, they don't seem to be in the format of the Guwahati High Court.
No. What is it? We have not seen.
The looks, the documents also appear to be the same. My lords, again, another point to consider. If my lords will see page number 381 and 390,
Just a minute.
I'm just pointing out a fact for your lordships to consider.
381 and
381 and 390. 381 is basically the first page of the affidavit in reply filed by respondent number 3. And 390 is the first page of the affidavit in reply filed by respondent number 4. My lords will see that the format in which the document has been framed is very innocuously the same. That's all. Nothing else. I personally have never seen an affidavit in opposition drafted like this. My lord, like I said, I end by saying that corruption it always happens clandestinely, and therefore inferences have to be made by reading between the lines. Nobody will declare publicly that I am indulging in corruption, my lords. Very, very grateful, my lords, for your very, very patient hearing.
okay, heard Sri R. Chaudhary, learned counsel for the petitioner. Also heard Sri P. Chaudhary, learned standing counsel.
Well, it's assisted by Commissioner.
Standing counsel, PWD, semicolon, Sri T.J. Mahanta, learned standing counsel, assisted by Sri A. Barua, and Sri for this number 4, Sri Chaudhary, the learned standing counsel, had also handed over the records of the case. Hearing is concluded, judgment is reserved. Okay, we'll try to give it as soon as possible.
Very grateful, my lords.
Obliged.
Mr. Chaudhary, the record.
I looked at the brief documents are also there.
Give the entire record, please. After they go to. Huh? What was this, madam? IA. IA for extension.
Lordship, in this case,
Yes, who's for
in
the
that
other
case-
side? Mr. Chaudhary, you're for the other side. Yes, can it be disposed of today?
Lordship, only one thing, as given by my friend, the document whereby their appeal they have could not file it. Lordship, on getting, I got telephonic instruction that they were originally registered under the West Bengal Tax Department. They were given a temporary ID in Assam to file in, and that has elapsed. They have asked me for another 2-3 days time to.
Then we'll have
give-
considered this immediately on the reopening.
Yes, Lord.
Madam?
yes, your Lordship.
Okay. Heard, Miss
22nd.
Noelia, learned counsel for the petitioner appearing online. Para, Sri B. Chaudhary, learned standing counsel, GST,
Yes.
GST. Has submitted that there are certain developments which are towards redressal of the issue involved, and he prays for some time to obtain the necessary instructions. Para, in view of the above, matter is adjourned to be listed on, can you have it on 22nd?
Yes, madam.
22nd.
Yes, your Lordship.
Obliged.
Much obliged.